So Rule 102 and 104 require you to consult with your client about the means to which their objectives are to be carried out. And both of these rules tell you that if the client expects assistance that would require you to violate your ethical obligations or violate the law, you have to consult with the client and explain to them about the limitations on your conduct. You can't necessarily do something just because your client demands that you do it. Getting a cramp on my thumb here. Okay, the rules also require competent and diligent representation. This doesn't mean you have to press for every advantage, use offensive tactics, or not treat people with courtesy and respect. It also does not preclude you from agreeing to reasonable requests for extension of time that don't prejudice your client. A couple places in the rules talk about respect for rights of others. Rule 300 and 804 prohibit exhibition of bias or prejudice based on a number of protected categories against the judge, court personnel, parties, witnesses, opposing counsel, or others. Rule 404 prohibits you from using means that have no substantial purpose other than embarrassment, delay, or burdening another party. We all have a duty not to abuse the legal process. 301, which is very similar to Civil Rule 11, you must have a basis in law and fact for any claim or defense that you bring. 804D says it's misconduct to engage in conduct prejudicial to the administration of justice. A few more rules: duty to expedite litigation, and a couple things I wanted to point out that are in the comments. It's improper to fail to expedite litigation solely for the convenience of you or your client, or to frustrate the opposing party. And it's also improper to realize a financial or other benefit from delay in litigation. That's not a legitimate client interest. Your client may think so, but it isn't. A few more rules that I'm not going to discuss because I think Brendan and George will cover these when they're talking about civility in the courtroom. 303, candor to the tribunal. 304, fairness to opposing party and counsel. And 305, impartiality and decorum of the tribunal. You have a duty not to engage in disruptive conduct, which also, by the way, all of those duties apply in depositions as well as in trial. Now, the ethical duties that I've just mentioned, uncivil practices can be considered a failure of all of those duties. It unnecessarily increases the costs of litigation, or it doesn't even have to be litigation. It doesn't serve your client's legitimate interests. It negatively impacts the court's perception of your credibility, and it creates a barrier to effectively resolving the matter, whether it's litigation or a transactional matter or a negotiation, whatever it may be. So many of you, if not the majority of you in this audience, are not lawyers. So why do you care about these ethics rules? Well, here's why you should care. And here's why the lawyers should make sure that you care. Lawyers are required, this is Rule 503A and B, required to ensure that the conduct of non-lawyers that they employ complies with the lawyer's ethical obligations. And a lawyer can be held responsible for conduct of a non-lawyer that would violate the rules of ethics if engaged in by the lawyer. And you can't do through another person what you are ethically prohibited from doing. That's Rule 804A. So if a lawyer can't have ex-parte communication with opposing party, you can't have your secretary or an investigator or someone else that you supervise go out and do it for you, essentially. Okay, now let's talk about civility and professionalism codes. Most state bar associations and many others have adopted civility rules. They're generally aspirational rather than mandatory. typically not enforced by sanction or disciplinary action, with a caveat that I will mention in a second. They're intended to encourage lawyers to observe principles of civility, and they echo many of the same requirements of the rules that I've just mentioned. Now, although generally these civility codes, and the New Mexico code is in the materials if you picked it up, generally they say they're aspirational rather than mandatory, but I got to tell you that more and more states are imposing disciplinary sanctions against lawyers for violations of civility. We had a lawyer in Arizona, I think within the last year, who received discipline in part for violating Arizona's creative professionalism. Al pointed a case out to me that is, I think, in the recent Bar Journal, the Bar Bulletin, a lawyer who was formally reprimanded for engaging in uncivil behavior. He engaged in disruptive conduct before the tribunal, including engaging in speaking objections after being admonished not to, asking questions related to mandatory sentencing after a motion in limine precluded him from doing so, and generally argued with the judge and disrupted the proceedings. He was suspended from practice in the federal court for 6 months and referred to the New Mexico State Bar. The New Mexico State Bar conducted a hearing and found that his conduct in the federal court violated Rules 305D, which Brendan will reference, and 804D. And referring to zealous representation again, his defense was that he was only acting as a zealous advocate and attempting to protect his client's rights. It was a criminal case. And the New Mexico Bar said, numerous cases have held that zealous advocacy does not extend to disruptive conduct in the course of a trial and in knowing violations of clear and specific directions from a trial judge. As the Sixth Circuit has noted, there is no right to a revolution in a United States District Court. The lawyer's duty is not to defy a judge's orders, but to follow them. And this fellow received a formal reprimand and assessed costs of the disciplinary proceeding.
Some of you also might recognize this is the same person that his name is Chip Benny. He also had a little incident where he shot a client in his office not too long ago. So Mr. Benny is having a rough time right now. I hope all of your thoughts and prayers.
He obviously has problems beyond simply being rude in the courtroom. Oftentimes when there's one problem, there are other problems. Now, I'm just going to quickly run through some of the common themes that are in these civility creeds. They want you to be courteous and civil in your communications, avoid rudeness and acts of disrespect, respond promptly to communications by opposing counsel, consult in good faith on scheduling, grant reasonable requests for extensions or scheduling changes, don't request extensions solely for the purpose of delay, notify opposing counsel in the court promptly of any canceled appearance. Don't just not show up. Don't time filing or service of motions in a way that unfairly limits another party's opportunity to respond. I don't know about you, but when I was practicing in front of at the Equal Employment Opportunity Commission, I can't tell you how many Christmases were ruined because my opposing counsel filed a summary judgment motion or some motion right before Christmas, and my response was due like right after Christmas or right after New Year's, and so I had to work through the holidays. That's really not very civil. Don't use discovery for improper purposes. Stipulate and agree where you can, and prepare documents that accurately reflect the agreement of all parties. Now, being civil doesn't mean roll over and play dead. Civility and courtesy doesn't mean that you cannot be a strong and, if you will, zealous advocate for your client. Al wanted me to be sure and talk about how public servants, such as us, all of us here, are held to a higher standard. Now, you may or may not think that's fair, but it's true. Government lawyers are held to the highest standards of ethics and professionalism. We're not simply advocates for our clients. We're not hired guns. We're here to act in the public's interest. So it's not just about winning. In private practice, it may be about winning. Your client hires you to have a successful result. But in our case, the ultimate objective is truth and justice. And that applies to all government employees, not just lawyers. We're all here to serve the public, not just clients, and it applies to everybody we deal with, the judiciary, opposing parties, counsel, our clients, members of the public, and our coworkers.